Hey everyone, I'm Attorney Otto and welcome back to Q&A with Attorney O, where I help Florida families protect their assets, avoid unnecessary conflict, and plan with confidence. Today's question is a very important one and it's one I hear often. Can my family fight over my assets even if I left a will behind in Florida? And the short answer is yes, my friend, they can try. But whether they succeed is a completely different story. And understanding what opens the door to fights and what closes that door is one of the most powerful ways to protect your family. So let's get into it. Most people believe that once they have a will, everything is settled and nothing else can happen. But a will is a legal document, and like any legal document, it can be challenged. That doesn't mean the challenge will succeed. It doesn't even mean the challenge is strong, but the ability to challenge is there. And that usually happens when someone feels blindsided, someone feels left out, or someone feels that they were treated unfairly. So, give you a few examples. Sometimes a sibling may feel like they were deserving of more. They expected more. Sometimes a second spouse and an adult child from a previous relationship are not aligned. Sometimes a family member believes someone else had too much influence. In my experience, the legal issue doesn't really usually spark from something actual legal. It's sparked out of emotion, shock, confusion, or unmet expectations. So I want to talk to you about the legal grounds, the actual legal grounds for challenging a will in Florida. In Florida, a will can only be challenged for very specific reasons. The first is lack of mental capacity, meaning someone claims the person was not mentally capable when they signed the will. The second is undue influence, which is the classic, someone pressured them or manipulated them into writing their will or into changing their will. The third is improper execution. Maybe it wasn't signed with two witnesses, or it wasn't done consistent with Florida's formal requirements for how a will should be signed. And the fourth is fraud, where someone claims the person was tricked or misled. Now, these might sound dramatic, and sometimes they are, but most of the time they stem from misunderstandings or assumptions, not actual foul play. Florida courts require real evidence for these claims. Feelings are not enough. But here's where the real life conflicts come in. Let me give you a quick example, and I'm going to leave out names for privacy, of course. A man in Miami updated his will late in life, leaving more of his estate to the daughter who had been caring for him daily. The other children who lived out of state, they were shocked and disappointed. They didn't expect the change. Their dad never told them it was coming, and they felt the daughter must have pressured her dad into making these changes. And so they challenged the will. And in the end, it was found that the man actually had full mental capacity. The signing was witnessed properly. The daughter was not even present when he met with his attorney to request these changes. The will seemed to be valid in every way. But because the children were surprised and hurt, they filed a challenge anyway. And the probate, which should have taken 6 to 8 months, dragged on for nearly 2 years. And in the end, as I said, the will was upheld exactly as written. So the question we were first asked is, can they challenge? Absolutely. They challenged in this case, but they didn't win. But the damage to their relationships was done, and the family spent thousands of dollars in the process. This is the emotional layer that people often don't consider when thinking about estate planning. I'm going to give you one more example. A woman in Broward County left a small but meaningful piece of property to her niece. Her adult son was deeply upset. He believed that he should have inherited it all because he was the child, the one son. So he challenged the will, claiming his mother wasn't well when she made the change. He said she couldn't have been well to make that change. But medical records and the attorney's notes showed she was perfectly capable and the will was signed properly. So again, the challenge failed, but the probate was delayed and family tension grew. The will was strong, but the emotional reaction is what caused the fight. Now, this is why clarity and communication matter. Surprises are the number one reason someone decides to challenge a will. And here's the part nobody tells you. A will does not stop people from having feelings. It doesn't stop resentment. It doesn't stop jealousy. A will stops people from winning the fights they may choose to start, but it doesn't stop them from trying. And in Florida, when someone challenges a will, everything slows down. Assets are frozen, court hearings begin, lawyers get involved, and the family is forced to relive everything under scrutiny. It's not that the will is weak, it's that the process takes time. And that's why so many people choose trust instead of relying on a will alone. A trust keeps everything private, it avoids probate, and most importantly, it creates a much stronger barrier against challenges. Trust challenges are far more difficult to win because the assets aren't going through the public court system of probate. And when everything is private, organized, and already assigned to the trustee, there's very little for someone to argue over. So the trust puts the right people in charge immediately and gives your family clarity without involving the court. If you want to reduce the chances of a fight, the best steps are pretty simple. First, make sure your documents are drafted properly and signed correctly under Florida law. Second, make updates while you're healthy so no one can claim you lacked capacity. Third, use a trust if you want the highest level of protection. And fourth, and please don't forget the fourth, communicate. Not every detail. I'm not saying to tell everybody everything you're leaving behind for them, but at least the general outline of your plan. The fewer surprises, the fewer challenges, the fewer heartbreaks. So, can your family fight over your assets even if you have a will? Yes, they can try, but with the right plan, proper documents, proper execution, and the right structure, they're very unlikely to win. And even more importantly, you'll reduce the emotional burden on the people you love. You can't control how people will feel, but you can absolutely control how protected your wishes are. I hope that answer was helpful. And if you have a question you want answered on a future episode, send it my way. I'm Attorney Otto. Plan wisely, live confidently, and I'll see you next time.